Hello and welcome to Law 2024 Online, Residential Property Shape the Debate, with me, Lawrence Howland, David Keithley and Richard Snape. So today's question and answer session is due to last about an hour, and we're going to be going through as many of your pre-submitted questions as possible in that time. And a recording of today's session will be available on the website in the next few days, so please do keep an eye out for this. I'm going to be hosting today. I'm Lawrence Howland, and I'm the Director of How Compliance Limited and the Director of Risk and Compliance at Buckle Solicitors. And How Compliance is a compliance services, provides compliance services and training to professional service firms, particularly law firms. I was previously with the SRA for 3 years, and I spent 30 years in law enforcement with Majesty's Revenue and Customs as a financial investigation SIO. And during that time, I was also the Fiscal Crime Liaison Officer to the British Embassy in Beijing. I've spoken and written myself quite extensively on financial crime typologies, including for the Law Society and LexisNexis. So far as today's discussion goes on residential property, I am very much an interested observer, and I'm really looking forward to learning more from our experts. On the topic of our experts, our guests today are, as I said, David Keithley and Richard Snape. David was admitted as a solicitor in 1982, and until he retired from full-time practice, he was a partner of and the head of residential property at a legal 500 firm. And David now uses his very extensive experience and understanding of practical conveyancing to cut through the academic niceties and make things relevant for busy practitioners out there. David's also a contributing editor to the Law Society Conveyancing Handbook. So far as Law 2024 Online is concerned, David also presents sessions on protocols for exchange of contracts and holding to order, and the impact of short-term lets on leasehold covenants. Moving to Richard. Richard's been the head of professional support at Davitt Jones Bald since 2002, and he speaks at numerous courses for law societies all over the country. Also various public courses, in-house seminars with solicitors firms, and he's also spoken extensively to local authorities and central government bodies. And Richard's areas of specialism include commercial and residential property, particularly in relation to local government law, conveyancing issues, development land, commercial property, and encumbrances in relation to land. So nice to see we're in very safe hands with David and Richard. As part of Law 2024 Online, Richards also presents sessions on planning law for conveyancers and how to respond to new residential inquiries. So, hi, Richard and David, and I'm going to jump straight in and start going through some of the pre-submitted questions that we've received. So, can I ask David, do we know yet when the Law Society are going to introduce the revised protocols for exchange of contracts?
The short answer, Lawrence, is no. The Law Society said that they were going to respond to the consultation during 2024. There has been no response so far. Whether that response has been delayed because of the ongoing furore about the TA6, I don't know. I suspect there may be a link between the two. But watch this space, really. I suppose it's. I think they're, from what I understand, they're committed to it, but we don't know. We don't know when. Interestingly, as I've been going around the country talking about it, it's apparent that very few firms were even aware of the consultation, and therefore even fewer appear to have responded to the consultation. So it may be that the Law Society won't have a lot to look at, but we'll have to wait and see what they come back with.
Yeah, I think you're probably right. I think I don't think they want to do two controversial things at the same time.
Yeah.
The TA6 5th editions through first.
Yeah.
And then make
I
I think you're absolutely right. I think the vast majority of firms have never heard of it.
No, indeed. I mean, the exchange protocols are, yeah, okay. They do introduce some new certainties, which is fine, but I think that the hold to order protocol is probably a good idea, because at the moment it's a complete wild west as far as what hold to order means, because it's not regulated in any particular way. So, yeah, there is some merit in that aspect, even if they don't go ahead with the exchange protocol points. But I mean, I've been saying for years that the current exchange protocols, exchange formula, sorry, are massively out of date.
Yeah.
According to the protocol, according to the existing formulae, you can't exchange using email, but you can exchange using telex. Richard and I are grey enough to know what telex is, but the vast majority of people,
Speak for yourself.
yeah, yeah, yeah.
Sadly, I remember telex as well.
Yeah, indeed. So, yeah, so I think that's relatively straightforward. But yeah, watch this space on that one.
Okay, so moving on to the second question, Richard, are the changes to planning permission enforcement periods retrospective?
Yeah, to a large extent, yeah. I mean, the regulations, I mean, the background, it's only England, this, I should stress, and planning amongst other areas is getting very, very different in England and Wales. But I'll give you the background. I mean, sort of historically, planning enforcement periods for building, mining, engineering works, and also private dwelling, single dwelling conditions were 4 years from the date of the planning authority becoming aware of the breach, and 10 years for other breaches, such as, well, basically change of use and planning conditions. And it was in the Levelling Up and Regeneration Act, which received the Royal Assent last October the 26th, that I was going to change. And the actual act itself didn't make quite clear, but the regulations bringing in the changes came in April the 25th this year. And it's not the best of interpretations, but it says that if the building work had been substantially completed before April the 25th, then you'd still be in the old regime. But from April the 25th, there's a 10-year enforcement period in England for everything, including building, mining, engineering works and private dwelling. They also say that if you'd already breached the single private dwelling condition prior to April the 25th, you basically would still be a 4-year time period. And the question is whether what substantially completed, sorry, means. I don't know if you got any comments on that.
Yeah, I mean, I made that very comment yesterday when I was doing a live presentation in the hotel where I'm currently ensconced. But it was essentially that point that in years to come, people will need to know what was the state of the building work on the 25th of April. And that's not going to be very easy to determine. It's going to be yet another problem for the future.
Well, I think substantially changed, even if you do know what the state of the building. I know this Royal Town Planning Institute amended their guidance on enforcement, and they basically say that you should be taking photographs of your building right now, or back in April.
Yeah.
And the building work for if there's disputes in the future or enforcement is attempted in the future. And even then, they seem to be, we're going to have lots of cases, potentially, what substantially changed means.
Yeah.
And it's going to cause problems in particular when you're building on a stage-by-stage basis.
Yeah, yeah, absolutely.
Because you might just find that you sort of retrospectively, by starting the next stage of building, sort of make the original building, which was in the 4-year time period, subject to a 10-year time period.
Yeah.
So it's yet another piece of legislation that is very vague, but you and I can spend.
We've also got a similar issue, haven't we, with building regulations, which they've extended that, and they basically say that's where the work was was completed by the 1st of October last year. Well, again, how do you know when the building works were complete?
It's I mean, that's again England only, I have to stress, and not Wales, but because it used to be building regs enforcement periods would be 1 year.
Yeah, it's now 10.
Prosecution's 2 years, but enforcement period's 1 year, and that's gone up, as you say, to 10 years. And they didn't make clear the primary legislation, just Building Safety Act, needless to say, just amended the original Building Act, and it just says for 1 year, read 10 years. On the face of it, it looks like it's retrospective. I know the building safety regulator, who's this overseeing role now, they're saying they don't think it's retrospective. And if they say it, I suspect the local authorities will not be too concerned.
I mean, I've been basically saying that I don't think it's retrospective either, on the grounds that the section of the BSA doesn't say it's retrospective, but the BSA does in other sections say that those provisions are retrospective.
Yeah, I take that, but
It's an argument either way, isn't it?
yeah, if you look at the Building Safety Act, the amended version, if you just look at it as it stands today, it just reads 10 years, and it would be nice for them to tell us.
Yeah.
I suppose the other thing on both building regs and planning permission is that just because local or planning authorities or enforcement authorities can enforce doesn't mean to say they will.
Yeah. Yeah.
I know the insurers are not particularly concerned about it. Premiums haven't gone up. They're expecting huge numbers of claims. If there were huge numbers of claims, I think you'd see the premiums go much higher.
Yeah, the risk is fairly low for them, reflected by the premiums they charge anyway, isn't it? So,
yeah. They should consult people like ourselves, David, before they bring this stuff in.
absolutely, yeah. Yeah, absolutely. Yeah, I'm just holding my breath for government to call me to say, can I help them with their new legislation? I suspect.
Don't get me onto the renters, right? But that's for next time. But anyway, yeah.
So, David, going back to the conversation about the revised exchange protocols, are the new protocols going to be compulsory for all firms?
Well, the Law Society, the draft basically said that it wouldn't be compulsory for all firms, but it would be compulsory for CQS firms. So essentially, if it goes ahead on the basis of that draft, then CQS firms will have to use it. But what isn't clear is what happens if we've got a firm that's CQS dealing with somebody that's not CQS. I mean, licensed conveyancer, for example, what's going to be the way of sorting that out? So again, a comment I made again yesterday is that the protocol, I think, will probably need to be amended to record the fact that if we've got, say, a licensed conveyancing firm which refuses to adopt the new protocol, that a CQS firm can continue to use the old codes or whatever method. But we'll have to wait and see what comes out of the consultation as far as that's concerned. But it's again a bit of a mess. They can't force licensed conveyancers to do anything. They can't force firms that are not bound by CQS to do it. So have to wait and see.
I think they got the same issue with the TA6 5th edition.
Yeah, of course. Yeah.
In January.
Yeah.
With the proviso if you can get hold of the 4th edition in the future. But I think I've talked to numerous not about the protocol, but I've talked to numerous licensed conveyancers who currently use the protocol. And they say they're not going to use the protocol because they don't want to use the TA6 5th edition.
Yeah. And I've been talking about that as well as I go around the country in this busy time of the year, and I've only come across a very small handful of firms that are using the 5th edition.
I've come across a few, more than I would have imagined, actually. I was talking to a firm doing an in-house course online on Monday, and they say they'd already, before the announcements that it's not going to come in at the end of June, they'd all adapted their software and this kind of stuff, so they decided to continue with it.
Right. Okay, well, I think there was one lady in the room yesterday who said she was using it, but after we'd finished the discussion, I think she probably changed her mind and gone back to the 4th.
I've done a few courses like that.
Yeah,
but yeah.
Well, I think we're going to be returning to the TA6 a little bit later in this session. But for the time being, Richard, next question on my list: how should inquiries be responded to without being negligent?
Well, one way of not being negligent is not respond to them. But I won't repeat the cases I was mentioning in the webinar. But there are a whole series of cases going back to the 19th century, culminating in a case from just over a year ago called Rosser and Pacifico from Cardiff, which basically has said that if you respond by saying not aware, it can be a representation that you've taken reasonable steps to find out. I suppose the famous one was Tyndall in Cambridgeshire, that you've taken reasonable steps to find out. What can't be a misrepresentation is rely on your inspection or survey. I mean, that's, you're not actually committing yourself or limiting your retainer. I've always thought surveyors are much better than lawyers at limiting their retainer. And rely on your inspection or survey. If you ask me a non-standard inquiry, which is not relevant for that particular transaction, I think that's the safest way of doing it. Rely on your inspection or survey. No investigations have been made. Our client's not an expert. what you probably can't do is put disclaimers down, and there's a subtle difference between sort of stating something as a fact, and then you can't rely on this. That probably falls foul of Section 3 of the Misrepresentation Act. What you can do is just refuse to answer. One of the problems with the TA6 5th edition, which is the talking point of conveyancing, it's the New Building Safety Act, is that we've got questions which not so long ago, that would have been my response, which are now standard inquiries, depending on what happens in the future, about construction materials and the likes, fire safety, mobile phone signal.
It's also interesting in that that Rosser case that the judge said that the buyer was entitled to rely on the sellers in reply without making further investigations themselves, on the basis that the seller knew more about the planning situation than the buyer would have done, and the buyer was entitled to rely on it.
I thought that bit of it flies a little bit in the face of previous cases, though.
Yeah.
Because there was that there was several cases over there, McMeekin and Long, and the Law Society used to quote a case from 1852 called Cooper and Stevenson, which basically said that the buyers could be negligent if they don't check the seller's responses are correct. As you say, it just, everybody could be negligent if they don't check the seller's responses are correct, basically, or take reasonable steps. But Rosser did seem to go a lot against that. Yeah,
I mean, I've been covering it in various guises over the last few months, and one of the questions that was raised is, were Rosser's solicitors negligent in not picking it up? Well, I'm not aware whether or not she sued Rosser, whether she sued her solicitors or not. But
see, David, you said not aware. That means you're representing you've taken reasonable steps to find out.
Yeah.
But they so you have to. Yeah, I've not seen anything on that.
No.
But you do wonder, what was happening, that they missed that. It's in the conservation area of an Article 4 direction, which is what the facts were about.
Absolutely. So we won't know, but lessons to be learned always, of course.
Yeah, I remember years back when I think it was the TA6 3rd edition came in, and the Law Society's sort of discussion about the TA6s, and basically, because this is for the older members of the group, because David and myself will remember the Part 2s of the Seller's Property Information Forms. Which a whole new generation has never heard of. They were around until October of 2006. But when the TA6s came in, and they used to have basically something that the lawyers didn't bother filling in, that said more or less the same as Sindel, you're representing, if you fill it in, the lawyers have taken all reasonable steps to check the client's responses are correct. And that could include looking at previous files. People didn't fill in that. The Law Society was saying that the Part 2s went in 2007, but Sindel is still there. That's what you're representing anyway. And well, it's still there, lurking behind the scenes. It does fly in the face of the 5th edition as well.
It does.
Yeah. So anyway, better move.
Okay. So, David, another question that's coming is about clients' authorities, and the question is, why do practitioners need to get the client's authority to exchange contracts using a release?
The basic point, Lawrence, is that the Law Society have expressed the view, and I can't find any reason to argue with it, that solicitors don't have an implied authority to release contracts without having clients' authority to do so. And part of, this is already part of existing Formula C requires authority from the client, and that's been carried forward into the proposal for the new release protocol. And to be honest, one of the issues which I've been addressing as I've been talking about this going around is that even if the old codes stay in place and people are using Formula B and mangling it when it should be Formula C, that's just we've had this for years, that people have been using Formula B as a means of exchange when there's a release, and that never has been and never will be Formula B, but that's a side issue. But on the basis that when you give a release under the new protocol, you're giving an undertaking to the other side that you will not withdraw that release on that day. And that effectively means that you're going to need to make sure you've got your client locked in, so that your client can't withdraw the authority on that day either. And I've been saying to people that even if these new protocols don't come in, then I think that the form that's been proposed is probably a very good thing to do anyway. Because I've had this previously in practice many years ago, when I gave a release on a sale, having had the authority from the client, the release on the purchase, sorry, having had the authority, and about half an hour later, the client phoned back to say that he'd just been notified that redundancy consultations were starting at his firm, and he now wasn't sure whether he was going to have a job, so he wanted to pull out of the exchange. I said, well, I wasn't sure if I could because we'd already given the release, but fortunately, I was able to get hold of the other solicitor before he released it further up the chain, and we were able to nip it in the bud while he clarified what was going on at his firm. But yeah, that would have been nasty. I mean, if I'd exchanged and the client came back to me and said, I tried to get hold of you to cancel the authority, it would have been an almighty mess. So I think it's important that firms at least get their client to acknowledge. I mean, there is an inherent risk in using the release process. It's a minimal one possibly, but and if I do an exchange, I mean, if Richard and I do an exchange with you, and there's three of us involved, and I exchange with you on my client's purchase before I've exchanged with Richard on the sale. So I've committed my client to buy without actually having absolute certainty that we're going to get the money in on the sale. And in the meantime, we don't know that Richard's client hasn't phoned saying, I'm sorry, I want to pull out. I've changed my mind. But under the existing system, there's nothing in place to stop that from happening.
Yeah. But
under the new system, that will hopefully be addressed.
Just don't answer the phone. That's how I've found the answer to be. But it happens, but thankfully it doesn't happen too often.
Doesn't happen very often, no.
But yeah, I think it's no bad thing. Yeah.
Perhaps an illustration of one of the fundamental SOA principles, acting in the best interest of the client. Best interest of the client can change, in a worst case scenario from hour to hour or minute to minute.
The worst I've ever come across was quite a few years ago. It wasn't exchanging; they were about to complete. Long chain of people who were just about to complete Friday lunchtime, and first thing in the morning, the client was on the phone to the solicitors to say, I can't go ahead with completion. I'm not going to be available because I've been arrested by the police in a dawn raid for drug dealing, and thought you should be the first to know. With all his money in your account, and they had to report him, and none of the chain moved. And he'd been told by the police, you've been arrested for drug dealing. You're allowed to make one phone call, and you can contact your solicitor. So he decided to contact his conveyancer to get him off. That's
well,
the sweetest.
We're in danger of straying into an area which is one of my favourite subjects. So perhaps rather than do that, I should move on to the next question. And in fact, the next question does rather touch on that issue, which is, Richard, are there criminal offences attached to responding to inquiries?
If you believe the Law Society guidance, it's as they are at the moment, the consumer protection from unfair trading regs, or specifically an amendment regs, which are going to be replaced. It's European legislation. It's going to be replaced sometime by the Digital Markets Competition and Consumers Act, which received the royal assent just before Parliament prorogued. But I've not seen a date for that. I don't know if you've seen a date for parts of the implementation of that.
I haven't, no.
But it's going to be exactly the same. It's the enforcement is going to be different. But the consumer protection regs basically say that if you're a trader who makes a misleading statement, or more worryingly, misleading omission to a consumer, which to a significant degree causes them to enter into a transaction, it can be a criminal offence, the maximum 2 years prison, which brings in misrepresentations. I did mention this, so I don't want to repeat what I sort of mentioned too much in the webinar, but the most obvious example of that would be estate agents. But I remember back in 2016, it was February the 29th, it was the leap year. leap day, the Law Society produced guidance that they didn't substantiate initially, that said they think it can apply to domestic conveyances when you're acting for the sellers or landlords. You're making potentially misleading statements or omissions to consumers, and that could be a criminal offence, which is quite frightening.
It is, yeah. Yeah, I mean, around that time, I had a meeting with the Conveyancing and Landlord Committee about various issues, and that cropped up, and I basically, gave them both barrels about what the difficulties they were causing the profession by issuing that guidance.
The initial guidance had no kind of substantiation of that. I remember 3 of us we used to do the lecture circuit. The other 2 are retired now, and I'm the only one left. We contacted the Law Society, and about a year later, we got a response that they'd had a word with some QC, as they were at the moment, who was a specialist in European law. And this is what it assured us, that you have to interpret European law differently. And they quoted a case called Office of Fair Trading, I think it was, and Purely Creative, which was nothing to do with conveyancing. It was all about mis-selling prizes and magazines and newspapers, and it didn't seem to. I mean, there's a difference between estate agents and lawyers, as far as I can see, and conveyancers. Estate agents are directly making statements or omissions. It's what material information is about. What's designed to solve this. They're making statements or omissions to, members of the public, consumers. Almost certainly, like conveyancers are making statements or omissions to fellow lawyers. So I'm not sure why it's the same. I mean, the other obvious problem is that if you did find out information before you can tell if you're acting for the seller, before you can tell the buyer about it, you've got to get the seller's consent. And if they say no, you'd have to refuse to act. It's an almighty mess.
It is, yeah. I mean, there is a genuine concern out there as well that the Law Society in the TA6 FAQs, they say they do refer to that Office of Fair Trading case to try and support their view, but IN and many others are really concerned about the increased risk of misrepresentation and potentially criminal offences from the 5th edition. But I've almost suggesting to firms that it might be sensible to say that we're not standing behind anything that our client says in the TA6. I'm not sure how if that's going to work, but it's.
Well, I mean, the problem is that if you should know that the client's misleading or whatever. I always give the example. Supposing there's been, you've acted on that property, and the deal went aborted because of the survey, and they instruct you again. Even if the buyer doesn't ask about it, you're going to have to, with the client's consent, contact the buyer and say, "Oh, did you realise that your deal went aborted because of the survey?" And if you don't do that, according to the regulations, you're committing a criminal offence.
Yeah, and that's an exact example that I've been using, Richard, as well. The same situation, that it is it's an almighty mess. Conveyancers are, in many cases, conveyancers are rightfully fearful of a hand on the shoulder and being carted off to prison for replying to inquiries.
Yeah, well, yeah. I mean, I always think, I mean, if it applies to people acting for sellers, why doesn't it apply to people acting for buyers as well? But there's going to be problems with the financing. Do you have to state that? I don't know.
Yeah, interesting. Very interesting. I think there's a whole can of worms which this whole thing has been, the TA6 has opened up all sorts of issues which are just, I don't know, it's a mess. I think we can establish. I think we can all agree on that.
Yeah. Okay, so David, moving on to the next question. Where a deposit is being held to order, is it going to be sufficient to just write that on the contract, or should the standard conditions be amended?
Again, we've got a situation at the moment, held to order or H2O or whatever on the contract has no real legal meaning. There's nothing to back it up. I mean, say if I'm an elderly judge and I look over my half moon glasses and say to the barrister, Mr. So-and-so, can you please point me in the direction of where I can find out the meaning of held to order? The answer is no, I can't. But under the standard conditions do actually say that a deposit will be paid. So if the deposit is not physically being paid over, then in theory, I mean, I think if you're following it strictly, yes, the contract should be amended. But the new protocol does contain a suggestion that if the deposit is being held to order using the new held to order protocols, that the contract is amended to make reference to those particular parts of the new protocol. So by extension, even if it doesn't come into effect, it might be sensible to think about implementing that as well, because we've got a situation that you've entered into a contract, your client's entered into a contract saying the deposit's going to be paid, but the solicitors have made this sort of unilateral decision not to actually pay the money over. And so, that perhaps ought to be documented. I mean, it's a variation of the contract, isn't it? Section 2, it has to be recorded in writing. So it probably ought to be recorded in writing on the contract. As I know and Richard knows, it's never is. It just simply the letters H2O just magically appear on the side of the contract next to the deposit, and everybody's supposed to understand what that means. And in practice, we do, but somebody someday is going to come almighty unstuck when this when it all falls apart with an exchange, with deposits being held to order. And I mean, the worst I've heard is somebody gave an undertaking to hold a deposit to order until completion. And if completion doesn't happen, they were arguing, well, therefore I don't need to release the deposit. Again, fun and games there.
Yeah, I'm not sure about that argument, but
No,
I think you're quite right. I mean, you need some clarification again. I mean, the thing is that these things are not new, are they, as problems? And, we seem to be somewhat been going back a long, long time, and, we've not known.
Yeah.
It's one of those that people just seem to get away with.
You wonder sometimes if people's H2O hold to order because they realise they've forgotten to ask the client for the deposit, or magic. Being cynical now, but you do wonder sometimes.
I wouldn't comment on that one, but
So moving to the next question, Richard, this is another issue that is close to my heart, because it's an issue that you both discussed at length when I chaired the last conference I chaired. What should be done in relation to inquiries on septic tanks?
Oh, David's an expert on this. I mean, the 4th edition questions well, it's different in England and Wales again, I make that clear. But the 4th edition of the TA6s, I don't think is particularly good. I mean, they had to change it when it came in 2020. Within a few months, you had version 2, which was primarily changing septic tank questions. And the 5th edition, I think, is no better, right, honestly. I mean, it asks various questions about septic tanks and treatment plants and all these kind of things. The big concern in England, again, not Wales, is that if your septic tank drains into a watercourse as opposed to a drainage field, or it's a cesspit, or it's a Clargester, sort of as the brand name is, but if it drains into a watercourse, it should be replaced as soon as reasonably practical. I have one big problem. I don't know if Dave wants to chip in on this. That most of clients do not know whether they tend to know whether they're on the mains. They don't know whether they've got a septic tank. They don't know whether they've got a treatment plant. They don't know whether it's a Clargester. And they don't know if it's a septic tank where it drains. And I wouldn't mess around with inquiries on it if it didn't go into, if it wasn't connected to the main sewers, unless the client's got evidence of maintenance and this kind of stuff, which they don't tend to keep, and a lot of people never maintain. I just want a specialist drainage report to tell me.
Yeah, again, I think the point I'm making when I'm talking about this is, I'm becoming increasingly talking about these sorts of things, but I'm saying to firms, tell your client that they must get, if they're buying, to get an independent, proper test on the tank before they exchange, and that's going to require the tank to be emptied. So that it can be inspected properly, and they can determine from that where the outflow is, and whether the outflow is consistent with the general binding rules or not. and whether it needs to be replaced or upgraded. Because if it doesn't drain into a watercourse, then potentially it's okay. But yeah, the Environment Agency are now saying that if the tank is non-compliant, it needs to be replaced within 12 months of completion of the sale. And replacing a septic tank is not an easy issue. It's quite expensive.
Well, it can be very expensive.
Yeah. I mean, I've seen quotes of £30,000-40,000 to
The biggest I've seen is 50,000.
Yeah, it was ridiculous, isn't it?
I've seen 10,000, 8,000 as well.
Yeah.
But it's when they hadn't maintained at all, basically, and I won't go into the
I mean,
intricacies of it all because people might be having their lunch, but there is a heck of a lot of work involved to deal with the issue. I think specialist report, and then dependent on what the report says, if it drains into a water course, you deal with it in the contract as to who pays for it.
Yeah, that's right. You do get sellers who say, I've lived here for 20 years and I've never had to empty the tank. Well, afraid to me, that means you've got a leaking septic tank. So effectively, or it's because they do need to be emptied. I mean, people think, well, it doesn't need to be emptied. Well, it does.
Well, you're very, very retentive.
Yeah.
I think that's basically it. I'll have to check on this. I don't want to put them down for the sake of it. I don't think the 5th edition of the TA6 distinguishes between England and Wales.
No, I don't think it does.
The 4th edition does. It said,
I've got a copy of it in my bag. I could have a look.
Well, I always carry a copy with me.
Yeah.
But I'm pretty sure, again, I might be wrong on this, but I'm pretty sure it doesn't distinguish between England and Wales because none of that applies in Wales.
Yeah.
In Wales, you have to register all your tanks with Natural Resource Wales, and you don't get your registration, and presumably, and if it's a septic tank that drains into a watercourse or whatever.
Okay. So, moving on to the next question. David, this another topic close to my heart as I've just come back from holiday. Does the concern about short lets being a breach of the terms of a lease apply to holiday lets for a period of a week or two?
The honest answer is it's not entirely clear. The basic premise of the case, the Nemcover and Fairfield Rents case, which set the whole basis for this canon of law, essentially says that if the covenant is to use it as a private residence, then there needs to be a degree of permanence, and that somebody staying there, in the case of Nemcover, it was people staying there for a few days at a time. They said that didn't amount to permanence, and that it did breach the private residence covenant. But they didn't go on to say at what point does transient become a bit more permanent. And so, at what point does a let from a couple of days? I mean, we've got transient, but if somebody's a holiday let for a couple of weeks, is there more of a degree of permanence? I'm not convinced there is, because it's obviously you're only there for a couple of weeks, and so the same principles may well apply. It's an unknown, to be honest. And obviously, as I live in Cornwall and work with firms in Cornwall, it's an issue with some Cornish properties and properties all over the country, of course. But it's an area of law that is developing, I think it's fair to say. Interestingly, some of the more recent cases have not concentrated on the breach of the user covenant, but have gone after people using short-term lets on the basis of nuisance or annoyance. Because of the people coming and going at all various hours of the day, and raucous parties because they're on holiday and whatever, and causing annoyance to the neighbours. So that's another factor. So the honest answer is we don't know.
I think it's if you're just I mean, the other major, there's been several cases, as you said, was the Triple Rose and Beatty case in Newcastle, and like you say, it's got to be a degree of permanence, but it's when you're using it as a holiday. They were staying there themselves on occasion, but if you're using it for a couple of weeks and then a couple of weeks more and a couple of weeks more holiday lets, I think that's where it becomes an issue. I've talked to people in not so much in Cornwall but in Devon about it, solicitors, and they'll tell you that if it's something that really rouses the neighbours. If people are just, having a normal kind of holiday, a quiet, relaxing holiday, it tends not to cause problems. But if they start to have rowdy parties and the likes, that's when they'll do their best to get injunctions and shut them down and so on. And they have a lot of problems with it. It's a great unknown, not just into, I don't know if you mentioned, obviously the other things, are you in breach of your mortgage? What about your insurance for the property? You know, what does it do to, you know, if it becomes a sort of almost permanent holiday, let's, you know, should you be having a fire safety risk assessment as a commercial premises? When does it become liable for business rates and things? It's much more complicated than people might imagine.
Yeah, I mean, there is a case which I've forgotten the name of it now, but I covered it only yesterday, but it goes out of my head. We're basically saying that using it pretty much as a permanent holiday let or a permanent Airbnb or whatever does breach the not to use it for commercial purposes because you're converting it to a commercial hire property. So yeah, again, you're right. That brings in all the need for commercial fire regulations and everything
Smoke
else.
detectors on every floor with with rooms in them, and carbon monoxide detectors near solid fuel sources and all that kind of thing.
Sort of stuff. Yeah, and we're moving into. I know from what we've seen from what's been circulated that the same question arises later on about can a leasehold property, can letting it convert it into commercial rather than residential. Well, we could deal with that in the course of this question as well because it crosses over. Because the answer is well, possibly depending on the nature of the use.
I came across, again, going back to problems between exchange and completion. No, not just with pre-exchange like you were mentioning. I came across one where they decided to announce to the solicitors they'd already exchanged contracts, they had a mortgage, and they announced to the solicitors they're going to use it as a holiday let. So you had to, with your client's consent, tell the mortgagee, and the client, if the client said no, you'd have to refuse to act even though you've not, you've exchanged. The client said yes, they told the mortgagee, who promptly withdrew the mortgage.
Yeah, but that's actually a very legitimate point. It's a real issue about using these properties and people buying properties, knowing full well that they're going to use it for other than the purposes of the lease. And all we can do as solicitors really is make sure the clients are fully aware of the circumstances and the risks. And
somebody once told me, I won't mention names, it was a property being used as they purchased this property as far as I'm not sure if there's a mortgage company involved, but as far as the lawyers were concerned, the conveyancers were concerned, it was going to be a buy-to-let. It was in the Peak District, and they started using it as a holiday let. They got private residence covenants and not to run a business and that, trade or business covenants, and the neighbours stopped them, and they basically sued the solicitors for not telling them that, well, I don't agree with this. The insurers just refused to defend the claim, but they argued that if you know it's a buy-to-let, you should make clear that that's not a holiday let or an Airbnb.
That's an interesting point.
Yeah.
Another thing to beat us with.
So Richard, next question, and we've touched on this a number of times, but I will ask the question: how can the protocol be reconciled with the new TA6 property information form?
And this is the existing protocol, because the protocol is stage 15 and it used to be stage 32 of the pre-2019 protocol. Basically says that you shouldn't be raising inquiries that can be found out from the buyer's inspection or survey. It goes on a bit longer than that, or if the client's expressly requested and so on. And it also says that if such inquiries are raised, you should tell the clients that you don't have to answer them, and also that indiscriminate use of standard additional inquiries is or may be a breach of the protocol. And a lot of people have been asking how the TA6 5th edition squares with that, because you've got a lot of questions that even if the lawyers were sitting by the client helping them fill them in, then lawyers are not qualified to judge what they mean, like the construction materials and the don't get me onto the mobile phone signal and the health and safety, fire safety, structural safety. It says things like, are there any fire safety within the premises, and that could be white goods and the likes, and it's on the face of it doesn't. You're not supposed to raise them as standard additional inquiries. When the Law Society Q&As came out in early June, they said that it's perfectly acceptable within the protocol, because the protocol, we've made them standard inquiries. They're not additional inquiries, so you can answer them. You have to answer them, which seemed a bit of a sleight of hand to me. I'm sure you've got something to say about that.
Just a bit. I mean, they also did say in that those Q&As that the protocol would need to be amended to take account of the TA6, but they wouldn't amend the protocol until the TA6 had been pressed into use and they saw the issues that arose from the use of the TA6, which is a bit like, you know, bolting the stable door, as it were. You know, the protocol does need to be amended to reflect some of the real issues that arise from the TA6.
When people were using the 5th edition, when they thought it was going to become compulsory in June, and then lots of them on June the 14th, the announcements that we're going to consult and delay until January the 15th. People were telling me, well, the restrictive covenants question. Everybody was just saying that there are no restrictive covenants. You know, I find that difficult to believe, but clients don't know what a restrictive covenant is. If you left that to the estate agents don't know, and that's potential negligence claims, quite big time. You know, the whole thing is like that. I mean, and you know, the construction material questions, why are they there? I'm tempted to say, why is Japanese knotweed there? But that's been there for quite a few years. But I think you're going to have a whole series of disclaimers. It does say in the explanatory couple of pages at the, you know, towards the front, that if you don't know the answer, you basically should say so. And buyers shouldn't expect answers to, you know, issues that arose before the actual, you know, the property was, you know, previous owners of the property. But if you leave the answers blank, people were telling me they're just getting more and more questions from the buyers' conveyances. We want a response to this, and so on. And it was just causing absolute chaos.
Yeah.
Do you think it's going to come in January then, David?
The feedback I've had from people who have attended the live consultations is that it's virtually 100% of the attendees are saying, yeah, we don't want this. It's wrong. Yeah, we shouldn't be doing it. It's the trading standards have basically said it's the estate agent's responsibility to provide material information, if not the solicitors as part of the TA6. And I mean, I've taken part in the online consultation. And I was slightly horrified that the tone of the questions being put by the Law Society's agents is very much appears to be pushed towards trying to make the result everything's fine and we'll tack on with the TA6 exactly as it was.
I think you're right. I think they might change it a bit. They might just give a version 2 with a bit of a sop.
And one point I've suggested is if they want to press ahead with it and make it a protocol required form, then we need 2 versions. One which is used containing material information if the solicitors are instructed before the property goes on the market, and so that will never ever be used because clients just won't do that. Or another one which basically is the existing edition, which relies on the fact that material information has been supplied by the estate agents as they're required to under the trading standards rules. But the other problem we've got here is that Rightmove and Zoopla and the other portals have made it known that they don't intend to punish estate agents who don't upload material information. And trading standards have also said they don't have the resources to police it either. I did see a report recently to show that mostly when the survey was carried out of compliance across 2 particular areas of the country, various firms, and not one area was 100% compliant, and virtually no estate agent was completing the details about the restrictive covenants and whatever. And worryingly, some were not even including the bit about the EPC, and that's been going for God knows how many years.
I mean, a lot of estate agents, in my experience, don't know about it still. And a lot of estate agents aren't doing it. I've come across one story, somebody on LinkedIn, who said that they'd had an estate agent refuse to start marketing the property until the 5th edition had been filled in. And that's about the only example I've come across of that.
Yeah. I think the Law Society will press ahead with it, if nothing else for commercial reasons, because they make a hell of a lot of money out of licensing the.
I'm not sure we can say that on recording.
Probably shouldn't do, but we all know it's true, don't we?
These are all David's views, not mine.
Oh, allegedly, the Law Society make money out of licensing the TA6, and that they'll want to make sure that it retains the prevalent thing. I mean, it's legitimate. It's a commercial interest. I mean, I don't blame them for it. Yeah, they've obviously got a commercial interest in the TA6 remaining the prevalent means of completing material information. So you have to wait and see.
Okay.
I think they will press ahead with it in some form.
I think they will.
One of the other follow-on questions that's coming, we've talked about all the inquiries that are required. Why aren't there any inquiries about higher risk buildings?
Yeah, I'm all for additional inquiries, huge numbers of them. At the same time as the TA6 5th edition came in, they changed the 4th edition. Well, they introduced the 4th edition of the TA7s, the leasehold information, which actually became shorter, mainly because things that should be in the leasehold information inquiries were put in the general inquiries. I mean, there's one group of questions that seem to be missed out, and they are quite important. It's England again, like this bit of little legislation, it's part of the Building Safety Act, and again, it's not coming in Wales. They say they're not going to introduce the Building Safety Act provisions in Wales, which has made me think of moving there. You've got to have at least 2 residential units, and it's going to be 18 meters or 11 stories in height. And it has to be registered with the building safety regulator, who then call in files and the likes and safety case reports and put you under special measures in your higher risk buildings. It's all post-Grenfell legislation. If I was buying a flat in a higher risk building, I wouldn't buy it I don't think I'd want to act if the building hadn't been registered, or if there has been a safety case report called in by the regulator and it's under special measures. And there's no inquiries about that, and I think there should be. I've suggested in the webinar that you perhaps adapt the CPSE inquiries, which changed about a year ago, and ask the question, is it a higher risk building, and who's the accountable person, and check whether it's been registered. The register is a public document, but it's not accurate. There's a lot of mistakes in it. I think if you didn't sort of find those things, I don't think mortgagees would lend on a flat in a higher risk building that's not been registered, but there's nothing in the lender's handbook which amazes me either. So those are some additional inquiries I think you might just ask about. If you ask the question, is the building a higher risk building, you'll get the answer, refer the matter to your surveyor, and the surveyor will probably say, we don't know. Because there seems to be a lot of doubt as to how you measure higher risk buildings, just like leasehold protections. RICS, the Royal Institution of Chartered Surveyors, are saying that I can't remember the Law Society for this one, but the government's guidance is so inaccurate that they can't be sure of the measurements of higher risk buildings. Any comment, things about that?
I think I agree with what you say, Richard. That it's an area that is unclear. I mean, we're right. If you're buying a high risk building, you clearly want to know that everything is okay. I mean, it's a high risk building for a reason.
Yeah, I mean, I just wouldn't want to be part. It could affect your insurance. I'm amazed there's nothing in the lender's handbook. You've got the 5.14.17 to deal with the service charge caps and leaseholder protections. I've actually memorized part 1 of the lender's handbook, David, for my appearance on Mastermind, when it's going to be my specialist subject. But you need a 5.14.18, and you need some TA7 inquiries about high risk buildings. You've got inquiries about the leaseholder protections, but that's not, I mean, that asks the question, same in the 4th edition and the 3rd edition, that asks, are you a qualified leaseholder? And how many of your clients are going to answer that correctly?
Yeah, so this is a tricky one.
So we're getting towards the end of our time, gents. So I'm going to ask one more question, David, if you would. Is it true that the government intends to abolish forfeiture of leases? And if they do, is that going to impact on short-term lets?
Well, yes. I mean, in the King's speech, they have basically announced that they intend to bring forward legislation which will abolish forfeiture of leases. But the announcement focused more on the the forfeiture for arrears of rent, because you can lose it for relatively small amount of arrears. So to some extent, it's going to depend upon what actually comes out of the in the draft bill eventually, as to whether it's just forfeiture for non-payment of rent, or whether it's forfeiture for any purpose. Because if it abolishes forfeiture completely, then yeah, obviously yes, the whole question about the Nemkova case and forfeiture for short-term debts would fall by the wayside. But yeah, we don't know until we see what actually is brought forward. At the moment, it's nothing more than we're going to bring forward proposals to do that, but we don't know what.
Yeah, a lot of people seem to think it's this, we're going to introduce this draft leasehold and common hold reform bill, and they've missed the word draft out. I think a lot of the media it's consultation. If something does happen, it's a long way down the line, and it's...
Yeah, I mean, again, I'm saying I'm not expecting to see anything before the back end of next year at the very earliest.
I think later than that.
Possibly,
a lot later than that.
Yeah.
I mean, they were saying before the general election that we're going to ban all leaseholds within 100 days of getting into power. So they've got until next week to do that. But they, so people are going to be busy. I mean, the other issue which the Renters' Rights Bill should solve, hopefully, is that large numbers of long leases can't be forfeited because they're assured tenancies, because they...
Yeah, and that the Renters' Rights Bill is addressing that point, hopefully, as you
should
say.
Should hopefully not fall by the wayside.
Yeah.
I mean, forfeitures, not the most popular thing to say. It's a way of making people pay their dues, the threat, and you got relief from forfeiture. But we'll have to see if it applies to holiday lets and Airbnb.
So watch this space on that one, I suppose. Still plenty of
Watch
work.
this space. Watch this space seems to be the buzzword of the day.
Well, yeah, we're not going to give everything away in one session, are we?
Absolutely.
Got to protect our livelihoods.
This is going to keep the both of us busy till retirement.
Yeah.
But I'm not going to retire, David. I've decided I'm going to...
No, I'm not going to retire either.
I want to be the President Biden of the property law world. It's well into my 80s when I should have retired, until somebody takes me to one side and says, I think you should retire now.
Retire. You do realise that they've repealed the Law of Property Act, which is not you. So,
That's what I think. If I do, I'll retire.
Yeah.
I think our audience is going to be quite pleased to hear that neither of you are planning to retire imminently. So unfortunately, gents, that's all we've got time for today. Can I thank David Keithley and Richard Snape for participating in this session and sharing their knowledge with us. Thank you, everybody, for watching Law 2024 Online, Residential Property Shape the Debate, with me, Lawrence Howland, with David and Richard, sponsored by How Compliance. And please don't forget to join the solicitors group Law 2024 Online community on LinkedIn, where you can continue the debate and also be included in exclusive offers for any future events. If you purchase the online course, there is still time to watch the pre-recorded content. The expiry date, I understand, is displayed next to the webinar. For those of you that haven't, there's still time for you to buy the complete event, including a recording of this session. To book, just go to www.thesolicitorsgroup.co.uk, and you'll also find the online exhibition there. The exhibition is open for anyone who wants to visit. If you book the entire package, you can claim a free 1-hour CPD webinar from the webinar learning catalogue. That's worth £35 plus VAT. Finally, after viewing the online course, please do complete the feedback form that's available in the related links section, and you will receive your CPD certificate via email. Thank you, everyone. Thank you for the final time, David and Richard, and have a great day.